So what is a probate sale and how are they different than a regular transaction? I will say that I'm a California broker associate, though I'm familiar with many other states' requirements. I'd say in most states, there's similar principles, if not the exact same. Generally speaking, in probate, there's two types of sales, what I'll call almost normal, and the second would be with court confirmation. Almost normal means that there are certain paperwork differences, and most of the time it looks like a regular sale. There's a different disclosure when we list the property. In the MLS, we have to disclose appropriately to parties who might be looking to buy the property. Making an offer, there's usually forms that we have to disclose to protect the buyer, as well as put the seller, make the seller identify that they are verified to sign on behalf of the estate or not. But basically, that's paperwork. Once you're in escrow, normally the process looks the same. There's one minor difference in California that title companies, not the law, require a notice of proposed action, usually if you filed 15 days before the close of escrow. So normally what happens is the buyer clears all contingencies, and when they waive contingencies, we file the notice of proposed action. And as long as that's filed for 15 days, we can close on the 16th day. If all the parties who would be noticed on that case, that would mean the administrator, maybe creditors, maybe other beneficiaries, if they all sign the notice, they all waive it, then you don't need to wait the 15 days. So that's one way to speed things up if you have to. Otherwise, that's fairly standard. Now, obviously, if you waive contingencies, you want to close as quickly as you can. You don't want to file the notice and let it linger because some objector might raise their hand and decide to object on the sale. So it moves as quickly as possible at that point. The funds don't go to the seller, the person, but they go to the estate. So usually what happens is escrow wires to the estate's bank account. In most states, beneficiaries don't get money till the end of the probate being finalized. There's exceptions. So the money goes to the estate, not to the petitioner or the executive administrator until the end of the probate. And that's why they're anxious to get things done as quickly as possible. Now, a few little tricks is you can get reimbursed expenses. So if the petitioner or the executive administrator laid out money as expenses, they can get reimbursed on the sale of the property. And one way that I do it as a realtor is I'll pay for them and then I get reimbursed on the closing statement as part of the sale of the close. So as an agent, I can get reimbursed for any expenses selling the property as long as it's on the closing statement, like clean out, trash out, eviction, attorney services, things like that. Not attorney services for the probate, but attorney services maybe for eviction or other related actions. That's a normal probate. Now, the second type is what I would call court supervised, court confirmation sales. There, you have a buyer, and this is a big misconception in California, especially. You have what should be a regular buyer. Then at some point when they're ready to clear contingencies and raise their deposit, they clear contingencies and raise their deposit to 10% of the purchase price. They don't need to offer right away. And that's a big mistake many agents make. You have a regular sale period, and then they raise their deposit, then they waive contingencies. When the court brings it to court confirmation, at that time, the buyer has to be willing, a new buyer who wants to overbid would have to be willing to bring in 10% and buy with no contingencies, but not the original buyer. They have the normal inspection period to get to that point to waive contingencies and raise their deposit. Now, what happens is when the buyer's ready and waives contingencies, raises deposit, the attorney files the confirmation of sale with the court, and you get a court date, normally within, say, 30, 35 days. Some jurisdictions in California longer, some states longer, some shorter. When that day comes, every state's a little different, but the court will look at the confirmation and say, okay, this is ready to be sold unless somebody's here ready to bid more. And in California, they'd have to be willing to pay more than the current buyer by 5% plus $500. So on a $500,000 sale, a person has to be willing to walk in the door and pay $525,000, $500. That's 5% plus 500 more, plus walk in the door with a cashier's check for 10% of that made out to the estate, not to escrow. Plus, they have no contingencies. And so the court will say, is anybody here to overbid? If nobody is, they confirm the sale. If they are there to overbid, that becomes a court sale, and I'm going to deal with that in another video. So again, there's two types of sales. There's the standard sale, and there's a court confirmation sale. Really, if it's not a court confirmation, it's very much like a regular sale, except for you have the notice of proposed action and you have different disclosures and paperwork. They vary by state and sometimes by company as well, so you should check with your broker. Bill Gross, hope this helps you be more successful. Thanks.